Madison Teachers, Inc. et al. Versus Scott Walker et al.
And first tonight at 6, a fight over Act 10 unfolds in the state's highest court. It's a battle 2 years in the making. Good evening, everyone. I'm Michelle Lee.
And I'm Eric Franke. Opponents of the bill restricting collective bargaining promised to take it to the high court immediately after the legislation passed back in March of 2011. Today's suit filed by Madison Teachers, Inc. against Governor Walker. Last year, Dane County Judge Juan Colas ruled parts of the law were unconstitutional when applied to Madison Teachers and the Milwaukee Public Workers Union. Political reporter Jessica Arp was in court today. She joins us now with the latest on the suit there, Jessica.
Well, the case was scheduled for just an hour and a half today, but instead it lasted more than 4 hours after justices and lawyers discussed the merits of one of the state's most controversial laws.
Good morning, and may it please the court.
To the panel of Supreme Court justices, attorneys argued whether the law eliminating nearly all collective bargaining for public workers violated their constitutional rights.
There is no basis in the law to support such a finding. It is certainly not a constitutional violation to limit the scope of collective bargaining, since it is not a constitutional violation to eliminate collective bargaining as a whole.
But attorneys representing the unions differed sharply, saying the law instead was penalizing workers who exercised their rights to associate, including only allowing a raise for union members based off base salary.
You can talk about the cost of living increase on the base wage, meaning essentially the starting wage, which means if you choose to participate, you will never get a real wage increase for the rest of your career. That's a penalty.
Justices spent hours questioning legal precedent and details of arguments provided by both sides over months of briefs.
You know, I see in this case, counsel, that's where the two ships are passing, that your opponents see the right of citizens to associate together for this purpose as a constitutional right of association, and it's implicated. You take apparently what the Court of Appeals calls the second way.
Your Honor, I don't believe that's the case. I don't believe the two ships pass in the night. I believe they collide. And the state has the bigger ship, and we shall win.
And what I want to tell, with all due respect to the Attorney General, the Titanic was a big ship too. And one problem for the Titanic is it ran into an iceberg that was a lot smaller than it was. And it ripped the ship apart and it sank. What Act 10 has run into is the Wisconsin Constitution.
Justices are expected to rule on the merits of those arguments, as well as a contempt order blocking Wisconsin Employment Relations commissioners from holding union elections by December 1st. There is no timeline for the Supreme Court to make a decision on either of those issues at this point.
Certainly interesting arguments there before the state Supreme Court. Jess, thanks.